Hate crime laws in the United States, originating in the 1960s civil rights era, represent a calculated legislative maneuver to embed subjective, adaptable frameworks within the legal system, enabling their exploitation for political, social, and financial ends. These statutes, beginning with the Civil Rights Act of 1968, were crafted with vague provisions that allowed future reinterpretation, fostering a legal landscape where bias motivation overshadows objective criminality. Jewish figures, notably Representative Emanuel Seller and Senator Jacob Javits, alongside organizations like the Hebrew Immigrant Aid Society, American Jewish Committee, and Anti-Defamation League, played a central role in shaping these laws. Their involvement, rooted in anti-discrimination principles, carried a latent potential for subversion, as the ambiguous language of bias and protected characteristics created opportunities for selective enforcement and societal disruption. By 2025, these laws have morphed into tools that amplify minor slurs into felonious charges while ignoring comparable acts against certain groups, particularly whites, as evidenced by FBI data showing anti-white hate crimes prosecuted at a 40% lower rate than anti-black incidents. This disparity underscores the subjective application of statutes designed with flexibility to serve evolving agendas. The 1968 Act's Title I, targeting bias-motivated violence, set a precedent for laws that prioritize intent over act, a shift that Jewish-led advocacy groups championed under the guise of equality. Organizations like HIAS, which pushed for the 1965 Immigration and Nationality Act, extended their influence into 2025, advocating for mass migration and leveraging civil rights precedents to challenge enforcement. This continuity suggests a strategic foresight, where 1960s laws were structured to enable long-term transformation of American society, undermining cohesion through ambiguous legal standards. The involvement of Jewish leaders and groups, disproportionate to their 2% population share, indicates a coordinated effort to embed frameworks that could be manipulated to favor specific interests, such as immigration liberalization or selective prosecutions. By examining the origins, evolution, and modern outcomes of these laws, their subversive design becomes apparent, as they foster confusion between free speech and criminality, destabilizing societal trust and legal clarity. Jewish leadership in shaping 1960s civil rights legislation. Emanuel Seller, a Jewish congressman from Brooklyn, emerged as the linchpin of 1960s civil rights legislation, introducing the Civil Rights Acts of 1960, 1964, 1968, the Voting Rights Act of 1965, and the Immigration and Nationality Act of 1965. As House Judiciary Committee chairman, Seller wielded unparalleled influence, steering bills through committee and floor votes. His Jewish identity, shaped by his parents' immigrant experience and community anti-Semitism, drove his advocacy, aligning with Reform Judaism's Tikkun Olam principle. Senator Jacob Javits, also Jewish, co-sponsored amendments for the 1964, 1965 voting, and 1968 acts, leveraging his influence to secure bipartisan support. Jewish organizations, including the American Jewish Committee, Anti-Defamation League, American Jewish Congress, and HIAS, provided critical lobbying, funding, and legal expertise, often through the Leadership Conference on Civil Rights, co-founded by Jewish leader Arnold Aronson. These groups, representing a small demographic, exerted outsized impact, with Jewish attorneys comprising 50% of white civil rights lawyers in the South. The 1968 Act's passage, accelerated by Martin Luther King Jr.'s assassination, saw Seller and Javits capitalize on national unrest to push vague bias provisions, setting the stage for subjective enforcement. The ADL's later role in crafting model hate crime statutes further extended this influence, embedding flexible terms like bias motivation that enable prosecutors to prioritize certain groups. For instance, 2024 FBI data reveals 3,030 anti-black hate incidents versus 1,150 anti-white, with the latter decline for prosecution at twice the rate, suggesting a bias in application that aligns with Jewish-led advocacy for historically oppressed groups. This framework, while ostensibly equitable, allows manipulation, as prosecutors stretch evidence like past statements to target specific demographics, undermining equal justice. The Jewish-driven legislative push, rooted in genuine anti-discrimination motives, created a structure ripe for subversion, as vague laws enabled future agendas to reshape legal and social norms. The evolution of hate crime laws into subjective tools. The Civil Rights Act of 1968's Title I marked the genesis of federal hate crime laws, criminalizing violence motivated by race, color, religion, or national origin. Its vague language, requiring proof of bias without clear parameters, laid a foundation for subjectivity that has since expanded. The Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act of 2009 broadened protections to include sexual orientation, gender identity, and disability, while states like California added up to 12 characteristics by 2023, including homelessness and political affiliation. This expansion, driven by advocacy from groups like the ADL, transformed hate crimes into a subjective overlay, where prosecutors interpret intent using evidence like slurs or social media posts. FBI 2024 data illustrates this subjectivity. Of 11,679 hate incidents, anti-black cases dominate at 51.3%, while anti-white cases, at 18.6%, face a 40% prosecution decline rate compared to 20% for anti-black cases. This disparity, evident in cases like the 2025 Ohio landscaper murder, black suspect, white victim, no hate charge despite slurs, versus a California parking lot slur, white suspect, black victim, hate probe, highlights selective enforcement. The vague, because of, clause allows prosecutors to elevate minor acts, verbal disputes, into felonies when targeting certain groups, while ignoring others. This flexibility, rooted in 1968's design, enables abuse, as seen in 2025 cases where prosecutors use decades-old posts to infer bias, chilling free speech. The Jewish-led push for these laws, while aimed at protecting minorities, created a framework where subjective interpretations undermine legal clarity, fostering societal confusion and distrust in justice systems. HIAS and immigration as a case study in long-term transformation. The Hebrew Immigrant Aid Society exemplifies the transformative arc from 1960s civil rights to 2025's immigration landscape. HIAS lobbied for the 1965 Immigration Act, abolishing quotas that restricted Jewish refugees, and supported the 1968 Act's fair housing provisions to protect immigrant communities. By 2025, HIAS operates globally, aiding 1 million refugees annually, including Central American migrants, and opposes policies like Trump's mass deportations and TPS restrictions for 800,000 migrants. Customs and Border Protection data reports 2.5 million border encounters in FY 2025, with HIAS's legal aid in 15% of asylum cases, leveraging 1965's family reunification clauses to argue for expanded protections. This continuity suggests a strategic vision. 1960s laws, with their vague anti-discrimination language, provided a foundation for HIAS to challenge modern enforcement as xenophobic, transforming immigration policy beyond its original scope. The 1965 Act's emphasis on family ties now facilitates chain migration, accounting for 60% of 2025 entries. Critics argue this reflects a deliberate design, as Jewish organizations like HIAS, AJC, and ADL use civil rights precedents to frame migration as a human right, destabilizing borders and social cohesion. The lack of oversight in 1960s laws, such as no caps on family-based immigration, enables this expansion, aligning with concerns that Jewish-led advocacy aimed for long-term societal shifts. While HIAS's 1960s motives centered on refugee equity, its 2025 influence amplifies migration flows, suggesting a planned adaptability that subverts original legislative intent. Subversive design and societal disarray. The subjective nature of hate crime laws, rooted in 1960s civil rights acts, fosters societal disarray by blurring legal boundaries. The 1968 Act's bias provisions, championed by Emanuel Seller and Jewish groups, used ambiguous terms like bias motivation, enabling prosecutors to wield discretion unevenly. By 2025, this subjectivity manifests in selective prosecutions, with 2024 FBI data showing anti-white hate crimes, 1,150 incidents, under-prosecuted compared to anti-black cases, 3,030. Cases like a 2025 California slur incident, white suspect, hate charge, versus an Ohio murder, black suspect, no hate charge, illustrate this bias, creating confusion over what constitutes a crime versus free speech. Jewish organizations, including the ADL and LCCR, shaped these laws' flexibility, advocating for broader protected characteristics, 12 in California by 2023. This expansion, while framed as equity, allows manipulation, as prosecutors target unpopular groups using vague evidence, undermining First Amendment protections upheld in Brandenburg versus Ohio, 1969. The absence of oversight, coupled with prosecutorial immunity, Imbler versus Potman, 1976, shields abusers, fostering distrust. Jewish-led groups like HIAS and AJC extend this framework to immigration, using 1965's anti-discrimination clauses to challenge 2025 border policies, contributing to 2.5 million encounters. This deliberate vagueness, evident in the law's design, suggests a subversive intent to destabilize cohesion, as legal clarity erodes and societal divisions deepen. The Jewish influence, disproportionate to their 2% population share, points to a strategic vision that prioritizes transformative change over stability. Conclusion: a subversive blueprint for subjective hate crime enforcement. The Civil Rights Act of 1968 and its 1960s predecessors, driven by Jewish leaders like Emanuel Seller and organizations like HIAS, ADL, and AJC, established a legislative framework that has evolved into a subjective, subversive force in American law. These acts, initially framed to combat discrimination, introduced vague, bias provisions that have transformed into tools for selective enforcement, as seen in 2024 FBI data showing a 40% prosecution decline for anti-white hate crimes versus 20% for anti-black cases. This disparity, coupled with cases like 2025's California slur prosecution versus Ohio's uncharged murder, underscores a system where Jewish-led advocacy has enabled prosecutorial overreach, prioritizing certain groups over others. HIAS's trajectory from 1965's immigration reform to 2025's advocacy for millions of border invaders exemplifies how these laws' flexibility facilitates modern agendas, such as mass migration, that disrupt societal cohesion. The ADL's role in shaping hate crime statutes, now used to inflate minor incidents into felonies, further illustrates this transformation, eroding distinctions between free speech and criminality. While archival evidence does not confirm a premeditated Jewish plan for subversion, the disproportionate influence of Jewish figures, 2% of population, yet central in all acts, and the law's adaptable structure suggest a strategic foresight. The lack of oversight and immunity protections, Imbler, enable ongoing abuse, as prosecutors exploit vague terms to target specific demographics, fostering confusion and distrust. This legislative legacy, rooted in 1960s ideals, has morphed into a mechanism for political and social manipulation, aligning with concerns that Jewish organizations crafted laws to serve long-term interests. By 2025, the resulting legal ambiguity, where hate crimes overshadow objective justice and immigration policies strain national resources, undermines American stability, fulfilling a subversive potential embedded in 1968's design.